Hello, thanks for joining us today at Estate Planning 101. I'm Dan Broccoli. I'm going to be your moderator today. I'm with Vanilla, and this is Vanilla Academy. This is our very first course in our Estate Planning 101 series. Today, we're going to be going over the introduction. This is a three-part course. So if you get a lot out of this, which we hope you will, we hope you'll join us for the other two parts of the course. And today I have two very special guests joining us that are going to help talk about estate planning from sort of two different sides of the coin, two different angles here. We've got Dominic Cazzetto. He's a financial advisor with Advice Period, and Stephen Wallace, who is an attorney at Accelerant Law. And I'll let them give a little bit more background about what they do and where they come from. Dominic, let's start with you.
Thanks, Dan. So I'm a financial advisor. I've been in the industry for about 20 years. My career started focusing on stock picking and asset allocation for high net worth individuals. And over time, just found that the greatest level of impact we could have on our clients' planning was not through the best investment returns. It was really through estate planning and tax planning. And so pleasure to be here today and to share some of our experiences from the financial advisor's perspective.
Great, thanks, Dominic. Very happy to have you. Appreciate that. And Stephen, can you give a little background about your what you do and your past?
Yeah, of course. So I'm Stephen Wallace. I'm with Accelerant Law. I've been in the industry for about 10 years now. I started my career out at the National Tax Office of one of the large accounting firms in their private client services group. And then I transitioned over to a AmLaw 100 firm where I worked in their trust and estates practice for a number of years. And then last year, I left with one of the partners there to start Accelerant Law, where we've been at for about a year now. And, at Accelerant, we focus on ultra high net worth individuals, estate planning. And we're really focused on, providing a really holistic approach to estate planning for our clients and working collaboratively with investment advisors to kind of achieve the client's goals. So I work closely with Dominic on a lot of relationships, and I look forward to presenting with them.
Perfect. Thanks so much. And we'll talk a little bit about the importance of having both an advisor and an attorney in your estate planning process here in a moment. But very happy to have you both and get both of your different expertise here. So just kind of lay out what we're going to cover today. Today is really the introduction. It's the first part of a three-part course. We're going to talk about estate planning goals, what the foundational goals to estate planning are going to be, the advisor and attorney roles, which we've talked a little bit about, and how those two roles can really work together to get the most for your clients. And then we're going to talk a little bit about the different types of estate planning, which we will also go into more detail in later parts of this course. So here we are, the introduction. Let's start with, I gave a sort of hat nod to this a little bit as you were introing, but let's talk a little bit about the different roles of estate planner, or rather financial advisor and estate attorney. I think, it's pretty common for traditional financial advisors to think of this as, okay, we do estate planning, but by doing estate planning, we just really hand it over to the advisor or the attorney, and then they deal with everything. But I think, Dominic, especially you deal with estate planning in a pretty intimate level on your day-to-day in a different way. And so could you talk a little bit about, let's start with you and talk a little bit about what your role in estate planning is, and then we'll also get Stephen's perspective on that too.
Yeah, financial advisors are really in a unique position because we have the most frequent conversations with clients and oftentimes know the most about kind of their intimate family details, about who they trust, how they wish for their estates to distribute. So for us, it's really about ongoing communication with clients and talking to them about their documents, and then ensuring that we are bringing in their estate planning attorneys or just general other advisors, or maybe it might be their CPA at times as well, to ensure that we're designing their planning that matches up with their objectives. Oftentimes those two can separate over time. So just keeping the team in constant communication as our client situations evolve or as opportunities present themselves has been something that we've focused on for a very long time, and ultimately creates a much better experience for the client and a much more efficient relationship with their advisors.
Great. And Stephen, as an estate attorney, how do you see your role, and how do you also work with advisors typically?
Yeah, I would say, especially at Accelerant, we kind of take a different view on working with advisors. I would say, traditionally it was very siloed, right? The CPA does one thing, the investment advisor does another, and the attorney does another thing. And so we try to work holistically and collaboratively with everyone because we think one, as Dominic said, achieves the best results for the client and it's the most efficient for the client, right? So the investment advisor has a lot more intimate detail of what the client's balance sheet is, what their goals are, and they can kind of relay all that information to the attorney. So the client's not telling three different people the same thing over and over again, right? And so that's really our approach to kind of working with clients. But I think, the roles are different in that, on a daily basis, Dominic is speaking with the client, has intimate knowledge of their assets. Whereas, the attorney a lot of times is providing strategic advice on what are the right assets to choose, what's the right structure, and then we're drafting the documents to kind of implement the plan that everybody's kind of worked on and agreed on together. And one thing I found about being an attorney is we kind of serve as a check on advice given from other advisors, right? So a lot of times the client's going to hear a lot of words from their CPA, a lot from their investment advisor, a lot from their insurance broker, have a bunch of acronyms rolling around their head. And so we kind of, serve as the check on that advice and tell them kind of what is the best structure to go forward for you.
Great. And, I spoke to one advisor at one point, great advisor, who he said that, previous to really getting deep into estate planning and estate strategy, he was worried that he was going to be encroaching on the attorney's sort of world. And he was worried about that going in. And I was wondering if you could speak to that and maybe allay some of those fears.
Yeah, no, I would say I fully embrace working with advisors. I think it's absolutely essential for the client to have a close relationship with all of their advisors, but in particular, their financial advisor. Because there's just going to be a lot of blind spots for the attorney that they're going to have no knowledge of. Because a lot of times, the client's not even going to think to raise they have an S corporation versus a C corporation, right? Or they have qualified small business stock. These are all important things that the financial advisor is going to be aware of and have an intimate knowledge of. And if you're just working in a silo, right, and you're just drafting documents in the darkness, you're leaving yourself open for a lot of issues down the road. So I embrace, working with advisors, and I know, a lot of estate attorneys are kind of moving towards that, working in a collaborative way with the other advisors.
Great. Well, thank you both. Appreciate that. Let's talk a little bit about the primary goals of estate planning. You want to kick us off, Stephen?
Yeah, sure. So I think, the really estate planning is a very personal endeavor. And I think one of the primary goals is really protecting yourself and your loved ones. If you don't have an estate plan in place, you're kind of leaving the state to decide how you want your assets to be divided when you pass away. There's a state statute that's going to say this is how the assets are divided. But you're also putting in place how you want to be treated with respect to your end of life choices as well, right? So those are all important things to do from an estate planning perspective. One of the biggest things for my clients really is asset protection for their estate planning, right? So by doing estate planning, you can put assets into a trust that can provide a shield of creditor protection for your family members after you pass away. And one of the things I tell my clients on a regular basis is, you may think, when you tell somebody, oh, you may do this for creditor protection. Like, well, I don't have any creditors, right? So, but for a child, the most likely potential creditor is a divorcing spouse. And so if you give your children their inheritance outright and the child ends up getting divorced, right? When 50% of all marriages end up in a divorce in this country, you're leaving those assets wide open to their divorcing spouse to have a half interest in. And I think one of the biggest things with, from a personal perspective is just providing certainty for your family, right? You can provide certainty that when you pass away, there's a clear direction on where your assets are going to go, who's going to receive them, and when they're going to receive them. And you also provide, particularly with respect to powers of attorney, which we're going to talk about later, and in particular, your healthcare power of attorney, you're really giving your family guidance on how you want to be treated with respect to the end of your life. And I think that's one of the great gifts you can kind of give to your family is the certainty that estate planning provides them. I think one of the big things that estate planning also does is, from my perspective, is tax planning, right? So when you draft estate planning documents, from my perspective, one of the big focuses is tax minimization or elimination of estate taxes in general, right? And so with estate planning, at best, you can eliminate estate taxes entirely. And at worst, you're going to defer the estate tax until the death of the surviving spouse in a married couple. So I think that's one of the primary goals of estate planning is tax efficiency. And then I think finally it's just a generational goal, right? It's the smooth transition of assets between generations. If you don't have an estate plan in place, it can be very clunky to kind of move assets from generation one to generation two. But by effectively drafting estate planning documents, you can make sure that the assets really move smoothly over to the next generation. And the family, when somebody passes away, it's a very emotional and tumultuous time in a family. And so by putting these documents in place, you can kind of take one burden off the shoulders of the family.
That's great. And Dominic, how do you think about these goals as an advisor?
Well, obviously the personal objectives are a very easy one to just because we know oftentimes what someone's trying to accomplish or how they would like to have maybe their end of life or other desires of how they want their assets to be spread out. So it's an easy way for financial advisors just to leverage the information that they already have about a client to help the attorney understand how best to draft documents or advise the client as to what structure will make the most sense.
Right. So we know why. How about when? When is it necessary to do estate planning? And is this something that happens sort of in a one and done fashion, or is this something that's ongoing? Dominic, why don't you talk a little bit about this here?
Yeah, I mean, I think an easy one, as we're talking about introduction here, we can, the very start of estate planning, as Stephen just alluded to, is ensuring that you have durable powers of attorney and advanced healthcare directives set up. Everybody needs those to ensure that if they're not able to make financial decisions or healthcare decisions for themselves, that they will have someone that they trust that can be able to get information and make those decisions for them at the time. So it's kind of across the board. We really emphasize that one, not only with our clients, but more importantly with their children, adult children who are unmarried, that they get these documents in place. So it's a very important one. Another very key time is if you are all of a sudden having children, and maybe you want to be able to ensure that that who will watch those children if something were to happen to you is very clearly documented, and that's not left up to the state. As Stephen mentioned, every state has rules for how those will be handled, but you want to have your own control of that. So that's another key one. And of course, any other life events, whether it's a divorce, or even from more of an advanced planning perspective, if you're about ready to have a liquidity event or some substantial change in your financial situation is upcoming, it's oftentimes advantageous to get in front of that 12 to 18 months in advance of anything like that happening. But of course, if you've already had something happen, it's not a bad time to also readdress your situation.
Right. Stephen, do you have anything to add?
Yeah, I mean, listen, I totally agree with Dominic. I think if you don't have, at a minimum, your powers of attorney in place, you should get them in place now. But I think everybody should have a will because you want to make sure that you can give your assets to your intended beneficiaries, right? And then if you're doing more advanced planning or you have clients who are doing more advanced planning, I think as an advisor, it makes a lot of sense to at least revisit those plans annually with the client, right? Sit down, if your clients are, have grants or they did a sale to an intentionally defective grantor trust, those are things that need to be revisited annually. And it's a nice touch point with the client as well, right? You can say, hey, we reviewed what happened in the past year. We're going to make the following payments. The plan looks great. It's working out just as we intended. Looks like it's going to be a successful planning technique for you. And then from a core document perspective, I think, you at least want to revisit your core documents every 3 to 5 years, pick them up, brush them off, kind of a review. Does the dispositive plan still make sense? Are you giving the assets to who, you still want them to receive? A lot of times with specific bequests, clients are going to say 5 years later, you know what, I don't want to give $500,000 to this person anymore, make it $300,000. That's a common thing I see. And then from, a fiduciary perspective, I think it makes sense to, at least revisit your fiduciary appointments on a yearly basis because, relationships between people are constantly evolving, right? And so the person you thought was right to serve as guardian for your children or as executor of your estate or as trustee of the trust that you create may not make sense a year from now. And so I think it makes sense to revisit those at least annually to make sure that, everything still makes sense for your estate plan.
That's great. And this is a place where advisors can really come in handy in terms of seeing the changing milestones or changing life events that might trigger a need for revisiting core documents or something that way. It seems like that's a really great way for the advisor and attorneys to be working together.
Yeah, absolutely. I would say, a lot of times the attorney's not going to know about a divorce, a birth of a child, any of those kind of life milestones. And so if the investment advisor is plugged into it, they can kind of prompt the planning for the client.
Perfect. So we're going to get into all of these things in more detail, but let's talk just very in sort of holistically in general about the different types of estate planning, basic and advanced. Stephen, can you walk us through these?
Yeah, sure. I mean, just really high level. When you think of like your core documents, these are like your essentials, right? Everybody needs to have one. They're your last will and testament. It's a revocable living trust in some situations. And then, as Dominic said, it's your healthcare power of attorney and your financial power of attorney. Those are your core documents. I think everybody needs those. And then your advanced documents are, trusts that you will create during your lifetime to kind of use up and leverage your estate and gift tax exemption, which we'll get into a little bit later. But some common ones an advisor will hear about are an irrevocable life insurance trust, an ILIT, a grantor retained annuity trust, a GRAT, a spousal lifetime access trust, a SLAT, and then there's additional trusts and structures we'll talk about. But as we go through this, you'll notice that in the estate planning world, we love our acronyms. So you'll hear these a lot. They'll be jumbled around your head. So we'll go through them later.
Perfect. Thanks. All right. Let's end with some estate planning pitfalls. What are some of the things that we should be watching out for as we create or help clients with their estate planning strategies, Dominic?
I think that estate planning can be very intimidating for financial advisors. So you don't always know about exactly what these documents necessarily mean, especially in the advanced planning side. And I think everyone wants to jump to this advanced planning as being like, being really what the client needs. But there's some very basic things that financial advisors touch every single day that we should be very aware of that have direct implications for a client's estate plan and can often be a really good starter to communication around their estate plan and also a touch point with their attorneys to ensure that their planning is matched up with their account titling. So we referenced a few different types of accounts below that pass directly to beneficiaries outside of an estate plan. So you want to make sure that all of those beneficiary designations match up with your client's goals and their current estate plan. A few examples are IRAs, 401k plans, life insurance or other pensions, any payable on death, POD, or transfer on death accounts. We often see these as financial advisors, and you don't always directly connect them to an estate plan. Another common one is joint trust with rights of survivorship. All of these accounts are going to transfer to the beneficiary via the beneficiary designation, not according to your estate plan. So as Stephen mentioned, referring to your annual review as who's in charge, who are the fiduciaries, reviewing your beneficiary designations is also extremely important. In my experience, we've seen ex-spouses, we've seen other relatives that are no longer living that are all beneficiaries that would directly go in to those people or be inconsistent with the client's wishes in their current planning. So just a couple of very good points that for financial advisors, you're already doing some estate planning if you're advising clients on how to structure these, or at least catching them and bringing them to light with the client and or their attorney.
You mentioned something that I think is a really good point. I do think that some financial advisors are afraid of the complexity of estate planning. It seems like this big, arduous thing, right? I would guess I'd like to drive home the fact that, some of the basic estate planning that we've talked about, powers of attorney, healthcare directives, these aren't hugely complex things. And when we talk about, advanced planning, that's often used with clients, 12.92 million and above taxable estates. These are ultra high net worth clients. And if you're not dealing in that realm, you may not even be touching that. And if you are, fantastic, at Vanilla Academy and here we'll help guide you and help get you a little bit more confident, and you'll be working very closely with an attorney like Stephen to make sure that you're confident in the plans that you're helping your client create. Do you have any other thoughts on pitfalls here, Stephen?
Yeah, I would say this is the biggest pitfall that we see on a regular basis is, you know, the attorney drafts an estate plan directing the assets towards person X, and then all the beneficiary designations directed towards person Y. And for a lot of clients, the most of their assets are comprised in these buckets right here, right? Their IRA, their 401k, all their retirement benefits. That's their biggest asset base for a lot of people. And so as an investment advisor, you want to make sure that whatever the attorney's drafted and what the client has agreed to as the dispositive scheme for their plan, you got to make sure it matches up with the beneficiary designations. If it doesn't, the whole plan unwinds, and it was really, all for naught.
Right. Yeah. Important. All right. So that's the end of our introduction course. Again, we've got 2 more parts to this 101 track here. Also want to encourage you to explore some of the articles that we've got on Vanilla Academy. If you're a little bit confused about probate or, what's involved in a power of attorney, we've got articles on all of those things that Stephen and others have helped us with to make sure that they're accurate. To the best of our knowledge, laws change, of course. Want to make sure that we put that qualification in there, but do explore that. Do explore our resource section where you'll find webinars and other materials that will help you on your way to get even more confident and deeper and better at estate planning. So we hope you'll tune in to the second part of our series. Thanks very much, Dominic. Thanks very much, Stephen. Really appreciate it.